Today, what do we see? We see a genuine public anxiety about what the NDC is doing. Unfortunately, Mr. Speaker, they are eating a forbidden fruit. Benasco, Issa, and Professor Richard Frimpong, I say, the ravening clouds shall not long be victorious. They shall not long possess the sky. Mr. Speaker, upon this foundation, I proceed to make my submissions opposing the decision or the motion before this House for the approval of 7 justices to the Supreme Court. Mr. Speaker, as I contribute to this report concerning appointment committee's report that vetted and is recommending 7 nominees to the Supreme Court of Ghana by majority decision, I will want this committee to first acknowledge the diligent work and detailed work of those nominees that appeared before us. Mr. Speaker, without doubt, these justices distinguished themselves. But whilst we acknowledge the diligent work of the committee and the detailed report before us, I must, Mr. Speaker, address this House on matters of profound constitutional gravity that transcend the routine consideration of judicial appointments. The report already recommends by majority decision, but the circumstances surrounding these appointments demand our most rigorous constitutional scrutiny. Mr. Speaker, this is not merely another parliamentary debate on appointment. It is a defining moment that will determine whether we remain faithful guardians of Ghana's democratic heritage or become complicit witnesses to its systematic erosion. The very foundation of our constitutional democracy hang in the balance as we consider this report this very evening. Mr. Speaker, I dare say that there is a constitutional crisis before us. Even as we debate these appointments, our Chief Justice sits suspended through procedurally questionable processes that make mockery of Articles 146 and 296 of our Constitution. Let us be abundantly clear about what we are witnessing. It is an executive that suspends one Chief Justice whilst simultaneously installing 7 new justices. Mr. Speaker, is this a routine feeling of vacancy? No, it is rather orchestrating a fundamental reshaping of our constitutional order. And it is the reason why, without any urgency, the report was laid today and government is in a rush to take this report and use its might in numbers to approve them. The confluence of events is neither coincidental nor constitutionally neutral. For the first time in our 4th Republican history, we face the specter of wholesale judicial transformation executed under the shadow of executive overreach. The appearance of institutional capture is not merely unfortunate, it is inevitable and constitutionally catastrophic. The framers of our 1992 Constitution, in their profound wisdom, established a carefully calibrated system of checks and balances precisely to prevent such concentration of power. Article 144 requirement for Judicial Council advice, Council of State consultation, and parliamentary approval reflect deep understanding that judicial independence requires democracy's very cornerstone. Today, we must ask ourselves with brutal honesty, are we faithful stewards of their vision, or we are presiding over its systematic destruction? Mr. Speaker, the breathtaking hypocrisy of our friends in government is hereby exposed by their very conduct. As I stated at the opening of the vetting of the nominees, this government hypocrisy reaches staggering heights that insult the intelligence of every thinking Ghanaian. The same NDC that relentlessly opposed the nomination of Justice Sofia Benasco Issa and Professor Richard Frimpong Opon under President Akufo-Addo, crying incessantly that the Supreme Court was bloated, now presents 7 nominees simultaneously without a hint of shame or self-awareness. Whereas, where was their fervent concern about the court size when 2 eminently qualified justices sought appointments? Where were their constitutional principles then? This gross dishonesty and rank opportunism reveals an administration driven entirely by political calculation, not constitutional principle. When President Akufo-Addo nominated 2 distinguished legal minds, the NDC discovered urgent constitutional concern about judicial bloat. Now, with 7 nominees presented en masse, they miraculously find compelling constitutional necessity. Such breathtaking inconsistency exposes a government that treats our constitution as a political convenience, embracing principles when expedient, discarding them when convenient. This hypocrisy, Mr. Speaker, is not merely embarrassing, it is constitutionally corrosive. It demonstrates that the NDC government views judicial appointment not through the lens of constitutional fidelity, but through the narrow prism of political advantage. Such an approach threatens the very foundation of judicial independence and constitutional governance. Mr. Speaker, we must confront an uncomfortable truth about Supreme Court's recent conduct. When fundamental principles of natural justice face systematic violation in the Chief Justice's suspension, our apex court retreated into comfortable silence when constitutional courage was desperately needed. The Supreme Court's reluctance to intervene in manifestly flawed processes being used to remove the Chief Justice represents a troubling departure.
Honourable Minority Leader, please. The provision on relevance comes to play. Now you are addressing something which is different from what is before the House. You are addressing the issue of the suspension of the Chief Justice. What we have are nominees for you to give prior approval for appointment to the Supreme Court. So you focus on that one, not on the other issue. Please.
Very well, Mr. Speaker. We always take a cue from you. When confronted with the procedures that plainly offend constitutional principles, the constitutional timidity sends a chilling message about self-preservation over constitutional principle. Mr. Speaker, we ask, are these nominees going to add up to what we are already experiencing? Mr. Speaker, what is happening currently, which makes it curious for us to consider the additional nominee, is not merely disappointing, it is constitutionally inexcusable. The Supreme Court, where these nominees are supposed to join, does not exist to preserve its own comfort or avoid controversy. It exists to courageously uphold constitutional principles, especially when doing so is uncomfortable or politically inconvenient. The question is, are these nominees ready? Are these nominees ready? Mr. Speaker, we dare say that so far from what we have been experiencing, it appears that the court has abdicated its constitutional duty precisely when Ghana needs its protection most. What we have witnessed is an institution that has declined multiple invitations to exercise the courage required to restrain executive overreach. Are these nominees able to challenge executive overreach? The institutional cowardice, though perhaps humanly understandable, represents a fundamental failure of constitutional guardianship. The people of Ghana deserve better and expect these nominees to do better. They deserve justices who understand that judicial independence is not a privilege to be enjoyed, but a responsibility to be exercised with unbending resolve. Mr. Speaker, we in the minority, considering the circumstance of their appointment, whereupon the President wrote directly to the Judicial Council and even directed them to expeditiously consider his nominees, we find that it is such a rich circumstance that compromises the independence of these nominees. Mr. Speaker, the past procedure had always been that nominations will come from various interest groups within the legal fraternity. The Judicial Council would deliberate upon, make a recommendation to the President for the President to exercise his power of appointment. This is not what happened in this circumstance. Mr. Speaker, by these appointments, we hold a view that the doctrine of separation of powers is under siege. Separation of powers, details across chapter 8, 10, and 11 of the 1992 Constitution, is not an academic abstraction. It is democracy's immune system. When one branch accumulates excessive influence over another, the entire constitutional organism suffers. The independence of our judiciary is not a professional privilege granted to judges. It is fundamental right belonging to every citizen who seeks justice in our court. We dare again repeat, the circumstance of these appointments, are they going to live up to this expectation? Mr. Speaker, history teaches us that democracy relies rarely. Mr. Speaker, history teaches us democracy can collapse through dramatic military coup. However, in situations where there is a gradual capture of independent institutions by political forces, democracy also collapses. We must therefore vigilantly ensure that the highest court remains a temple of justice, not a forum for political convenience. Mr. Speaker, the then NDC in opposition said that there must be merits, there must be seniority in the appointments. What did we see? The same people who complain that in appointment to the Supreme Court, there must be seniority in the consideration. One of the judges said he's barely spent 2 years at the Court of Appeal. There are seniors at the Court of Appeal. So wherein lies the principles of the NDC? Wherein lies the consistency of the NDC? You attack the Akufo-Addo administration of not being fair. You had the opportunity. Did you address your so-called system of unfairness? What are you doing? Mr. Speaker, the sacred trust of constitutional guardianship is squarely in the hands of our judges. To the nominees who now await our final approval, let me say to you directly, you seek to join an institution whose legitimacy rests not on popular mandate, but on public confidence in your commitment to constitutional fidelity. If confirmed by the majority, which they are desperate to do, you will become guardians of our fundamental law, trustees of our democratic values, and protected of rights that belong to all Ghanaians, rich and poor, powerful and powerless alike. Do not be moved by the might of the government to ponder to them. Mr. Speaker, the Supreme Court's authority derives from its moral standing, not from political alignment. Citizens must believe that when they approach the courts, they encounter justices committed to the law's supremacy, not to any earthly master. This confidence, once lost, proves extraordinarily difficult to restore. And this, I would want our nominees to think deep and reflect. To our nominees, I say to you, you will inherit a Supreme Court whose reputation, by virtue of the manner of your appointment, is being brought to question. Your duty is to weather the many storms and ensure that you pass the greatest test. Your task is not merely to occupy seats on that bench, but to elevate its standing through exemplary service that demonstrates judicial appointment based on merit, not malleability. Mr. Speaker, let me, in my further submission, proceed to address Article 125 of our Constitution. Article 125 declares that justice emanates from the people and shall be administered in the name of the Republic by the judiciary, which shall be independent, emphasis, independent, and subject only to this Constitution, unquote. This independence is not abstract. It must manifest in every decision, every interpretation, and every interaction with other branches of government. True judicial independence requires both institutional courage and intellectual humility. It means deciding cases based on constitutional texts and sound precedent, not political preference. The government has created an impression that it is sending these nominees merely on the basis of political preference to the Supreme Court. This we don't need as a country. The judiciary must know that in protecting minority rights against majoritarian excesses, it has to deliver judgment that thoroughly, perhaps can disappoint its appointor, because the Constitution demands nothing less. Mr. Speaker, our colleagues made allegations of court packing, and this they used to physically prevent the laying of the report in the 8th Parliament. Today, what do we see? We see a genuine public anxiety about what the NDC is doing, which questions judicial independence. These concerns can only be dispelled through demonstrated commitment to constitutional principle over political expedience. Through words spoken today and judgments delivered tomorrow. Mr. Speaker, we are, however, happy, in spite of our opposition in principle to these nominations, we are, however, happy with views expressed by each of the nominees on Article 66 of our Constitution. Mr. Speaker, each one of them expressed a genuine view on Article 66 during the vetting process. When confronted with their question, all 7 of them made it unequivocally clear that there is no interpretative ambiguity arising from its language. Their unanimous position that, quote, a person shall not be elected to the office of President of the Republic for more than 2 terms, end quote, means precisely what it says, no more, no less. It's constitutionally sound and reassuring. This provision admits of no creative interpretation, and any attempt to circumvent this constitutional limitation will represent judicial legislation of the most egregious kind. We pray that they will put their words into action when they eventually get it.
Honorable Minority Leader, once again, I remind you of relevance. Relevance. The subject matter before us today has nothing to do with second term or third term of a presidential decision. Relevance. Let's deal with the issues.
Mr. Speaker, with respect, Mr. Speaker, ordinarily I won't challenge you. The report captures Article 66. Mr. Speaker, my submission is coming out of the report. The report captures Article 66. But I would abide by that. Mr. Speaker, if you... Mr. Speaker, I must remind our distinguished nominees of the solemn oath they took before expressing their views to the appointment committee. They swore to speak truthfully and honestly about their constitutional beliefs and judicial philosophy. The people of Ghana witnessed their categorical statement on Article 66, and they must not be seen changing these views upon appointment to the Supreme Court by the majority. Let me be absolutely clear. The constitutional commitment they demonstrated before the committee must remain unwavering throughout their tenure at the judiciary. Citizens can only have confidence if our judges who are before us today get the courage to consistently maintain the views they express at the appointment committee hearing. Mr. Speaker, we as a parliament stand at crossroads. Today, decisions we make today will either restore public confidence in our judiciary or mark the moment when Ghana's highest court became an instrument of executive convenience rather than constitutional conscience. Let me issue this clarion call to our colleagues opposite me, who are so determined and so desperate to go through this approval process. Mr. Speaker, what we have for them, we, the minority, will not join them in their inconsistent Mr. Speaker,
please, you may continue.
We are not going to join them in their inconsistency in principles. Future generations of Ghanaians will judge their stewardship of our constitutional heritage and complicit in its erosion. They will ask whether we possess the courage to defend judicial independence when it faces gravest threats, or whether we chose comfortable silence over constitutional duty. History recalls that democracies die not through dramatic collapse, but through gradual institutional surrender. Each compromise, each accommodation, each failure to resist constitutional violation contribute to democratic decay. We must not be the generation that chose convenience over constitutional principle. And we say that the majority is choosing political convenience over constitutional principle. Mr. Speaker, we have already stated in page 137 of the committee's report, and same can be seen in the final recommendation at page 138. With your leave, Mr. Speaker, I beg to quote. The committee, in conclusion, all members of the New Patriotic Party, the minority, were opposed to and voted against the nomination of all the justices on the grounds that, 1, the appointment of 7 justices was inconsistent with the NDC's own principle We don't see it as filling vacancies, but we see it as reshaping a constitutional order at the very time that they have suspended the Chief Justice and they seek to dismiss it. Mr. Speaker, we also hold a view that the Supreme Court abdicated its constitutional duty and remained silent when fundamental principles of natural justice were violated. It is one of our reasons for opposing these 7 nominations. Mr. Speaker, again, we take the NDC by their own word. In the past, they said there was a judicial bloat. What has become of that argument? What has become of those 2 justices whose vetting was completed, the report was to be laid, and the NDC in opposition, in minority, physically prevented the laying of the report? And if I should quote the then Chief Whip, quote, Mr. Speaker, I said, Mr. Speaker, if the majority lays this report, there will be chaos in the House, unquote. Mr. Speaker, our decision in opposing and voting against all the nominees is not against the person of these nominees. Unfortunately, Mr. Speaker, they are eating a forbidden fruit. The fruit, the tree that is bearing them is poison. It's a poison tree. And the fruit thereof, which is they themselves, cannot be edible.
Honorable Minority Leader, may you now conclude.
Mr. Speaker, I conclude by saying that whilst we stand to rely on the rules of this House to reject these nominees, we note that even the majority with their 187 on this day that they want to push through have not been able to commandeer their numbers. They don't even have the numbers to take a decision. And Mr. Speaker, at the right time, an application will be made to challenge them that they don't have the 138 to take decision, and they cannot take decision on this matter today. I so submit, Mr. Speaker. Thank you very much.
Honorable Majority Leader.
So Europe and America now say this guy area Ghana nkwade ebusia send wave money transfer app na betimi aboa say wo send e de agu mobile money wallet so and our bank account so ubetimi easy sa app we e de asende ebusia network bi easy bi azu ubetimi e de asende sa so na first transaction no ubenya eye $20 free the answer will be easy eye promo code JSXM2 JXXM2 use our promo code or first transaction pay and I'll be $20 free.